Is Cheryl Day here?
No, she hasn't checked in.
Tatum here.
Yes, Your Honor.
Are you
Just
ready?
brought me to the courtroom.
Okay. On the record in the matter of the state of city of Lansing versus Daquan Tatum, 22-03189, appearance, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Tatum, who is standing to my right.
Mr. Tatum scheduled for a hearing today, and this is for a violation of probation. Are we having a hearing today?
Oh, Your Honor.
Okay, looks like the violations allege that you violated the amended order from November 18, 2024 for AgriHealth that you failed to submit to random year analysis on January 5th, January 17th, January 22nd, February 1st, February 10th, February 22nd, and that you failed to complete victim impact panel. That's please pleading to.
Yes, Your Honor.
That's correct, sir?
Yeah.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury.
Yeah.
Okay, you can put your hand down. You understand, sir, in this matter that you have the right to have a contested hearing.
Yeah.
You understand that you have the right at the time of that hearing to have the prosecution, which is the city attorney's office, put forth evidence that would establish your guilt as it relates to the alleged violations.
Yeah.
You want to not have a hearing today, or do you want to have a hearing? Okay, you want to plead guilty?
Yeah.
Okay. Anyone threatening you to do that?
No.
Any promises being made to you if you plead guilty?
Yeah.
What's the promise?
No, I'm sorry. No.
And you're pleading guilty to the violations because you believe you're guilty?
Yeah.
Okay, as to the violations that you failed to submit to testing, essentially since January 5th of 2025, how do you plead?
Yeah.
On a factual basis?
Thank you, Your Honor. Mr. Tatum, is it accurate that you underwent sentencing in front of Judge Simmons on June 17th of 2024?
Yeah.
And at that time, you were ordered to a term of probation.
Yeah.
And during that time, you were ordered to do random urinalysis or preliminary breath test screening.
Yeah.
And is it true that on the dates the court has already read into the record that you did not submit for testing?
Yeah.
And you acknowledge that's a violation of your probation orders? Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from your city?
On your honor.
Before to satisfy with the factual basis, I'll accept your plea. If I, your plea may plead voluntarily and intelligently. I have a recommendation from your probation officer indicating that your attendance at community mental health has been inconsistent, and that your overall attitude seems good, but your progress is poor and your acceptance of responsibility is fair. Says defendant has made minimal progress since the onset of his probation in June 2024. In 2024, defendant has not drug tested since January 18th, 2025, which I'm not sure how that works if he failed to appear on the 17th and 22nd of January. Nonetheless, defendant completed or never completed victim impact panel, which was ordered. Defendant was cautioned about jail time being held in abeyance, and defendant continues to be non-compliant with probation terms. Well, that sounds easy because it looks like November 18th, defendant pled guilty to violations. I said that he would serve 93 days Ingham County Jail to be held in abeyance if he had no further violations, and that he would enroll in outpatient substance use treatment, and that he needs to provide proof within 7 days, and that he would be testing 1 time per week for the next 60 days. And here we are. You can make allocation.
Thank you, Your Honor. I do acknowledge the time being held in abeyance from November 18th was something I was not aware of. I don't believe he had counsel on that, so there's nothing in our system noting that. I did talk to him today about the inconsistency and non-compliance with the testing. He fully acknowledges absolutely it is accurate. He's been inconsistent or non-compliant with the testing and victim impact panel. He was originally scheduled to complete the victim impact panel, and he acknowledged to me that work conflicted with it, and he chose to go to work when he should have chose to go to VIP instead. He acknowledges that's not something he should have reprioritized which one of those was more important. He did talk to me today about if the court does consider allowing him to continue on probation, that would be something he is prioritizing this week above all else. It's getting set up and scheduled for that victim impact panel attendance. He also did talk to me about the inconsistency of testing and acknowledged that's largely been a work and money issue. Told me he could test on Friday, has have the money then, and knows that if he's missing any tests after this, that absolutely the court is coming down on him. He is asking the court to consider allowing him to continue on probation, knowing full well it would be an extension of probation if it was originally due to end on March 17th. And he would be asking the court to consider that in his behalf.
Where does he work?
I was working at Walmart, and then I was working at MSU. Right now, my assignment ended because I was working through a temp service with MSU. Right now, they going to call me for a power plant job, but I'm trying to get in A-list property management right now.
When was the last time you worked?
Like a month ago now.
How is it that you're gonna use the excuse that you could not do what you were ordered to do as part of your probation because you had work?
I just taking care of the family. I can't provide for my family. I have to be there for my kids. My wife is working, and I have to watch the kids while she works. She works during the day.
Are you high right now?
No, I'm not.
Why are your eyes red and glassy?
Just waking up not too long ago.
You just woke up not too long ago? Because my courtroom reeks of marijuana right now.
Oh, it ain't me. You can come smell me.
I don't need to come over there and smell you. I can smell the marijuana
I
in
just
here.
came in the courtroom. You ain't
Okay.
smell it before I came here.
I sure
don't
didn't
disrespect
actually.
or
I was sitting in here until they
I
opened the
don't
door.
smoke weed no more.
Okay,
I don't.
okay,
I ain't smoked weed since I've been on probation.
good. But I don't know that. You know why? Because you
I don't.
you don't follow my orders. And if you think it's your responsibility to be out so you can take care of your children, then you would have thought it was your responsibility to follow court orders because you put yourself in this predicament. I did not. The court did not. The prosecutor did not. The public defender did not, and neither did the police. You took the actions that brought you before the court, and then you're not taking the actions to show that you have held yourself accountable and that you're willing to get on the right track. I give you a list of things to do and not very much things for you to do. You were supposed to engage in community mental health. You do it when you feel like it. You were supposed to be employed.
I've been going.
That's not what this report tells me. It tells me that's been inconsistent. You were supposed to go and complete victim impact panel, and I'm inclined to believe that was supposed to be within 90 days. You now are at a place where you should now be discharged, and I don't have it done. You know why I don't have it done? Because you had no intention of doing it. You want to do what you want to do. And you think that we want to sit here and continue to babysit you as an adult man. Why in the world would anybody property management hire you to do anything? You're not responsible. Why would they hire you? Based on what? You think if they see this video, they're gonna want to hire you? Would you hire you? No response? 30 days Ingham County Jail to be served immediately. Who is
This
this?
guy right here. Let me get the keys.
You step out of my courtroom, sir.
Yeah, you gotta go
You should
there.
have the key.
And that's not fair.
Hey, man, go on, man. That's fine.
I'm discharging his probation. I will refer the balance, well, I'm terminating his probation and referring the balance to collection.
And Your Honor, can I ask, because the report I have is over a month old at this point, is the accurate balance still 472.11?
That's what I have. You still have that? Yes.
Thank you.
Okay. Mr. Greenman is present. Are we having a hearing?
No, Your Honor.
On the record in the matter of the city of Lansing versus Richard Greenman, 20-01645. Appearance, please.
Good morning, Your Honor. Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Greenman, who is standing to my right.
Okay, Mr. Greenman was here for a hearing for probation violation. I believe that. Let's see. Okay, the violation I have here is that he amended or failed to adhere to the amended order of probation from September 20th, 2024, which is failed to engage in intensive outpatient for MMRS. He failed to attend sessions December 6th, December 9th, 13th, 12th, 20th, 27th, January 2nd, 3rd, 6th, 13th, and 15th. Is that accurate?
That is what I have, Your Honor.
And then I have another one saying that he failed to submit to testing at EverHealth on December 21st, 26th, 29th, and January 6th.
That is also what I have.
Okay, and you're pleading guilty to those violations, sir? Yes. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. And you can put your hand down. You understand that you have the right to have a hearing that contests the truthfulness of these allegations that you violated your probation term?
Yes.
Do you want to have a hearing today, or do you want to plead guilty? Anyone threatening you to plead guilty?
No.
Any promises being made to you if you plead guilty?
No.
As to the violations that was just read, how do you plead?
Guilty.
On an actual basis, please.
Thank you, Your Honor. Mr. Greenman, is it true that on March 18th of 2024, you underwent sentencing in front of Judge Simmons?
Yes.
And at that time, she ordered you to a term of probation?
Yes,
And as part of your probation orders, were you told that you would need to undergo random testing at AverHealth?
yes,
And is it true that as of the dates that the judge has read into the record that you did not test?
yes,
And that you know that's a violation of your probation?
yes,
Is it also true during that sentencing that you were ordered to engage in intensive outpatient treatment?
yes,
And is it true that as of the dates that the judge has previously read on the record that you missed outpatient appointments at MMRS?
yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the city?
None, Your Honor.
Court will accept your plea or find your plea to be made freely, voluntarily, and intelligently. My recommendation is rather old.
Yes, Your Honor, I believe there's a lot of, there's a lot of things that the court should be aware of that have happened since the writing of this report.
Yeah, he was at Rise since then, so
Yes.
I won't even bother following the recommendation you can allocate.
Thank you, Your Honor. That is absolutely correct. He is currently at Rise. He also did a residential, intensive residential treatment at Sacred Heart first. He put himself into that program. He recognized these violations being submitted in January. He knew immediately whether the court was going to tell him or not, this is something he needed to get for himself. He talked incredibly well on his own behalf when speaking with me, and I think he's going to take the opportunity to speak for himself because I think the language he used is really an insight into his perspective on sobriety right now. But he did go to Sacred Heart on February 20th. He completed and was released with them on March 6th. He went to Rise Recovery on March 13th. It's still actively with them and expects to be there for at least 90 days, possibly more. They'll do an evaluation once they get closer to that end date to see whether he needs more from them or is appropriate to move on to the next step of recovery. He is attending weekly therapist appointments at Victory. He is doing daily meetings. He does 4 days a week at Rise, and then on Fridays he does an outside community one. So that when he eventually leaves Rise, he already is set up working on a sponsor with his community 12-step meetings. He is over 30 days sober now, which is something he was quite proud about when he was talking to me prior to court today. He's been testing clean since he went to Rise Recovery in early February. He seems to be working really hard to get his life together. He knows that it's now or never. He's got his 3 girls, as he talked about. He's got 3 girls and a granddaughter for whom he is the primary caretaker. He spent his entire January making the focus of get as much money together so that they can be taken care of, so that he can put himself in treatment and make that his entire focus. It's just sobriety and recovery. And the court didn't need to tell him to do it. He did it. And I've noticed with people when it's something they decide for themselves and do it, it tends to stick more often than when we tell them to do it. Ms. Bayless's suggestion was that it happened on a term of jail, but I think he's already taken steps to do it himself. And so I would suggest to the court that allowing him to finish the work he's already started on an extended term of probation would be more appropriate than ordering jail and then going to residential. I think he's kind of worked hard to deserve or earn the possibility of the opportunity of taking advantage and showing the court that he can complete, he can remain sober, and he can take care of his responsibilities both to his family as well as to the court. And if I may, Your Honor, just one more thing. He used a phrase with me that I think spoke, kind of nailed down exactly where he is. He told me he's seeing this process as an opportunity, not a burden. And I think that shift in focus for him kind of defines where he is right now.
Did your client want to make a statement?
Yes, Sean. This is something I've been struggling with for over 20 years now. It's been a giant part of my life. It's been the biggest roadblock to everything that I've wanted to do with my life, everything I want to be, I hope for me and for my kids. These last 7 months, I had more clean time than I have in those 20 years, probably combined. So I found a new purpose, I feel like, in my life. Not only to do this, for me and for my daughters, but I feel like I owe it to the community, the recovery community, give back to people that don't know about this or that have experienced this kind of life that I found. So I feel like it's a great opportunity for me, to get through this thing in my life and also to be a help to other people who are lost, because this is a huge problem. All my friends pretty much are either dead in prison or messed up like that. So I feel like I owe it to them, owe it to my family, and and others, to get this right and get back. So,
I'm happy to hear that you are on your way to a future of recovery and that you've been clean for a record time at this point in your life and in your recovery walk. The difference between you and maybe someone else that I see before me that I wouldn't continue on probation is that you have taken actions on your own initiative to make the choices to correct and change your behavior. I did have a bench warrant at one point when I got the request and summons for violations. But you turned yourself in, and when you turned yourself in, you had already indicated that you were involved in getting some help. And whatever it was that made that light go off for you, that gave you the new hope, that gave you the new meaning of value for yourself and for your family, I hope you hold fast to that and hold on to it. Your children need you. They need you to be healthy. Your grandchildren need you to be healthy. And I'm sure that they're proud of you. I'm not proud that it took us this many times to get there, but if that's all it takes to get you to that area alive, then that's what we need to do. When you fell, you got back up, you kept trying. And that's the important part, is that you are still fighting so that you can make the cycle stop for you. Your attorney said it best. It's when you take the initiative and you make the change. I could court order anybody to do anything, but unless you want to do it, it's not going to happen. And so I am going to extend your probation just for 90 days, and that's because that's the time frame you're going to be participating in some treatment anyways, so that we can keep an eye and monitor that recovery to make sure you have that extra layer of support if necessary to make sure you're at where you need to be. I don't foresee that to be a problem. I don't foresee us to have to find you and bring you there. You brought yourself there. You're doing well. You've not had any negative tests or drops while you've been there. I expect that to continue, and I expect that in 90 days, Ms. Bayless can send me an order to discharge you successfully. If I discharge you today, it'd be unsuccessfully, and we don't want to do that. We want you to leave Rise with as much positive in your future as possible, okay?
yeah, sure.
And so with that being said, I am going to extend it 90 days. You've completed, I think, everything else that the court has already ordered you to do, including paying your fines and costs. It's just the aspect of your treatment that needs to be addressed. I don't think jail time is meaningful. You'll check in with Ms. Bayless, and then you'll continue with your treatment, and good luck to you, sir.
Sure. If not, I see.
You're welcome. Fadul Hassan, present. Is this the Are you employed? You're not employed?
I'm aware.
Oh, were you employed when you were arraigned?
Yeah.
You requested a public defender? Okay, it looks like you were likely not granted one at that time. Did you want to resubmit your application for a public defender to be re-reviewed since your employment status has changed? Or did you want to waive your right to counsel and represent yourself?
Aaron, I'm sorry if I may jump in really quickly. I checked the system over the lunch period, and I think my office has recently appointed me to his case. So I don't know.
Okay.
He may have
Sounds
already gone through the reapplication process.
Sounds good. Okay, so this is a driving unregistered and a no insurance?
That's correct.
Okay, what do you think you all want to do at this point?
I suspect it would be an adjournment, but I just realized the case was ours over the lunch break,
Okay.
so I haven't had a chance to speak with him yet.
Okay, you can have a seat and she'll chat with you in just a moment, okay? And let's see, I see Mr. Allen here. Are we ready on Tadanius Allen? I don't feel like I have enough files here for the rest of my document. Because I got a whole nother page to go and I don't have it. Thank you. I said that this couldn't be it. Okay. No, thank you. Let's see. On the record in the matter of the City of Lansing versus Tidonius Allen 25-00659 appearance, please.
Brendan Wendell, half the city of Lansing.
Have an attorney? Did you request an attorney, Mr. Allen? I'm about to say, I don't read minds. I don't know what you're saying. Okay.
We denied it.
They denied it, lack of indigency? Okay, so did you want to hire an attorney at your own expense? Did you want to appeal their denial, or did you want to represent yourself? You gonna represent yourself? Did you speak to the city attorney already? Oh, okay, was there an offer?
Yes, Your Honor, the offer was to Mr. Allen to plead to the trespass, and the city would dismiss the hindrance.
What do you want to do, Mr. Allen? You want to accept that? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, you can put your hand down. Okay, and you do recognize that you did not have to accept their offer. You could deny the offer and proceed to trial. You understand that?
Yes, sir.
Okay, because you have the right, as you stand here, you're innocent. So you have the right to maintain your innocence and require them to prove your guilt by first going to trial, and they would have to prove each element of the charge beyond a reasonable doubt. You understand that?
Yes, sir.
And you can be silent at your trial. They can't use that against you. You can waive your silence and testify at your trial. You can call witnesses that will testify for you, and you can question all of their witnesses at trial. You understand that? You want to give that right to trial up? Anyone threatening you to do that? Has there been any promises extended to you if you plead guilty today? Are you currently on probation or on parole?
No.
Okay, you understand that by pleading guilty, you may have to report this conviction to a job, your current employer or a future job application. Okay, as to trespassing, you plead guilty, not guilty, or stand mute. On or about February 27, 2025. Were you in the area at or near 520 South Grand Avenue?
Yes.
Can you read whoever that is? Is that in the city of Lansing?
Yes.
And that's in Ingham County?
Yes.
Is that also known as the Cata bus station?
Yes.
Okay, and were you asked to leave that area?
Yes.
And did you leave? Any additional?
Nothing else, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Affirm your plea, you may freely, voluntarily, and intelligently. I'm assuming you were arrested for this, sir. Okay, I'll give you 1 day Ingham County Jail with credit for time served and a fine of $50. When can you pay? I don't know, that you'll make payment, and you already know what to do if you need an extension, so you're free to go. Let's see, Mr. Lee. How are you?
I'm well, Your Honor, thank you.
Are you just hanging out with us today, or do you have a matter?
I do not have a pending matter. I just didn't know if my associates might need a little help, so I thought I'd be here.
Oh, we appreciate it. Thank you. Okay, I see, is it Mike? Ricky Adello?
Everyone does that. That's pretty good, Your Honor. It's Mike Riccadello. How are you today?
I'm well. How are you?
Hey, not bad. It's not Monday anymore.
I know it's Tuesday, so we're moving along. You're here on
Yeah.
behalf of Robert Unkeffer.
That's correct, Your Honor. And I don't know if that's him seated in the courtroom. However, I did tell him that this would be on Zoom and provided him the information. I don't know if he's in a breakout room.
Is there a Robert Unkeffer here?
He's checked in.
Okay, he's not appeared.
Well, I guess could you pass my matter and I will blow his phone up.
Sounds good.
Thank you.
Okay, Mr. Raleigh, did you have someone ready to go?
I have Bernard Greer ready.
Oh, okay, on the record in the matter of the city of Lansing versus Bernard Greer, 24-03184.
Brandon Wardell on behalf of the city of Lansing. Jacob Brown on behalf of Mr. Clear.
This is Bernard Greer the third, correct?
Yes, Your Honor.
Okay, today was the date scheduled for a pre-trial. This was for trespassing. How are we handling this matter?
Guilty.
There's that. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes, Your Honor.
Okay, you can put your hand down. You understand that you didn't have to plead guilty. You can maintain your silence and then they have to prove that you're guilty.
Oh, I didn't know that.
Yeah, you have that right. You can maintain your innocence. You don't have to prove that you're guilty. You can go all the way to jury trial and say absolutely nothing and you're still innocent unless they can prove each element of trespass beyond a reasonable doubt. Did you understand that?
I heard.
You can call witnesses that will testify for you, your lawyer, or you can question the witnesses that they call to testify against you. You can present evidence at your trial that you believe show a defense to the trespassing. Do you understand that?
I do.
Do you want to give up all of those rights?
No.
You want to have your trial?
Yeah.
Okay, so we'll set it for trial. It's not just the same thing. April 15th at 8:15. April 15th at 8:15 in person for jury trial, okay?
All right.
All right, do you have any questions at this time?
So it's in person, right?
You'll come in person, that's correct.
Okay.
Any additional matters for the record? Thank you, you're all set. We'll get you a notice.
Okay.
Ms. Sutter, I thought I saw her.
Yes,
Oh, okay. Ms. Sutter, were you ready on someone?
yes, Your Honor, Mr. Hassan is ready. I believe Ms. Wiseman is ready to go as well. Mr. Raleigh spoke with her.
Mr. Hassan, I just got his file. Okay,
Yes.
what are we doing with Mr. Hassan?
That's gonna be a request for adjournment for some compliance and documentation.
I haven't done it.
How much time?
At least 30 days, Your Honor.
May 6th at 10. May 6th at 10.
Thank you.
No problem. Do you have any questions for the court today, Mr. Hassan? We'll get you a notice. Oh, I think I only wrote that on 2 files. There's 3 files.
Yeah, there are, there's one OT file and 2 OIs.
Your Honor, I got a hold of my client, Mr. Unkeffer. He's going to be logging on. He got the date or the times mixed up.
Thank you.
Thank you.
No problem. On the record, in the matter of the city of Lansing versus Julia Wiseman, 20-00690.
Brandon Wardell on behalf of the city of Lansing.
On behalf of Ms. Weissman.
Okay, Ms. Wiseman has a drug paraphernalia from 2020. How are we proceeding on this?
Your Honor, I think we wanted to enter into a deferral arrangement. I'm not sure how this court handles that. Actually procedurally handling it, but we'd like to set this out for 6 months and with no new charges, the city would dismiss it.
So I'm sorry. What has happened between 2020 and now? Has she had new charges?
She does, in fact, she is on probation out of Eaton County, currently on a felony case.
She's got probation until when?
It's 2 years, correct?
2 years. So the request is for her to plead guilty. And then a deferred sentence for 6 months, no further issues, and this will be dismissed. That's what you want to do?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do, Your Honor.
Okay, you can put your hand down. You understand that you have the right to maintain your innocence.
Yes, I do, Your Honor.
You have the right to require the city to prove that you're guilty.
Yes, I do.
They would have to prove each element of the charge of possession of drug paraphernalia beyond a reasonable doubt at a jury trial. You can be silent at that trial and not have it used against you. You can waive the silence and testify if you'd like. You have the right to question any other witnesses that they call to testify against you. You have the right to subpoena witnesses that will testify on your behalf or present evidence that you believe show a defense to this charge. You understand that?
Yes, Your Honor.
You wish to give up those rights today?
I do, Your Honor.
Okay, anyone threatening you to get you to do that?
No, Your Honor.
Any promises being made to you if you give up these rights?
No, Your Honor.
Okay, and you are on probation, but obviously I'm assuming that that probation issue took place after 2020.
Yes, Your Honor.
Okay, so this is not likely to have an impact on that. But you understand that by pleading guilty, you could end up with a conviction that you may need to report to a current or future employer.
Yes, Your Honor.
It also could have impact on travel or immigration status that you may seek. So you may want to go to vacation in Canada and they could deny you for convictions such as this. You understand that?
Yes, Your Honor.
Okay. As to possession of drug paraphernalia, how do you plead?
Guilty.
Factual basis, counsel.
Ms. Wiseman, on February 23rd of 2020, had contact with police after a traffic accident.
Yes,
You were not driving the vehicle.
I was not.
You were a passenger.
Yeah.
Is it true that police found you to be in possession of drug paraphernalia?
Yes.
And you knew you had those items, those belonged to you?
Yes.
Thank you. I believe that's a factual basis.
Any question?
None, Your Honor.
The court will accept your plea if finding your plea to be freely, voluntarily, and intelligently made. You can make allocution.
Your Honor, Ms. Wiseman, the last 5 years, she has had some difficulties, to be sure. To that end, she is currently on felony probation out of Eaton County. We will be receiving some counseling and certainly intensive supervision regarding substance issues. Certainly, I think she's making a strong effort to just stay clean and sober, to not return to that way of life. And certainly there will be, she knows there will be serious consequences if she violates her probation or violates this court's orders going forward. I should note, she also has a couple of misdemeanor cases out of, I think, 55th District and one out of Shiawassee County, correct? And Livingston County, which will not affect her sort of overriding probation out of Eaton County. But just in the interest of candor to the court, I did want to mention those things.
Thank you. And fine is a $50 state minimum cost for $75 crime victim right, which you'll pay within the next 6 months, okay?
Okay, no problem.
I'm gonna give you a deferred sentence date.
September 30th and 9.
September 30th at 9 a.m. If there's no further interaction or criminal action, I should say, the city is going to have this dismissed, okay?
Okay, thank you.
Do you have any questions? And it's on citation, so you would just need to notice us that you want to dismiss. We don't need a nollie or anything. You're all set for today. Thank you. Good luck to you. Was is Weeks in custody?
I think you remember that a call that he sent to another county, but he'll be back in the ICJ tomorrow.
Okay. I see a Jeremy Henley.
He's with, on that LAFCO case that I'm here on, Your Honor.
Okay, are you ready to go in the breakout room with him?
I am, Your Honor.
Okay, I'll put you in room 1, Henley.
Thank you, Judge.
Thank you. Mike Dean? Definitely not the one we know. I'd see the P number. It's not the,
Yes,
it's
Your
not the
Honor.
one we know. Okay, which matter are you here for?
I'm here on case 00393 GC.
00.
23, I'm sorry.
23003 Sparrow
392.
versus Janae Matthews. Is Janae Matthews here?
I am.
Let's start your video. Okay, you have any more criminal matters? Freddie?
I don't believe so. I think
Those
these
are
folks in the back hall
yeah,
for,
civil.
Okay, so not seeing Don Garrett?
no, you're
No.
Okay. Tristan Weeks needs to be reset.
is he in custody?
He was transferred, I think, to a different
Yeah,
location.
he was rated to Clayton County.
Gotcha.
To Amber.
Have you seen Amber Thomas?
I have not gone. And I believe the last one is Cheryl Day, and I haven't.
I think
She addressed Cheryl Day already.
Oh, okay,
I
sorry.
think I already did that one.
I must have switched out for that. I apologize.
Let's see, Amber Thomas will be a big warrant. Mr. Oh, I'm confirmed, he's not logged in yet.
He said he was logging in right now as we speak.
Maybe he has
guess.
it down Zoom, maybe.
Yeah, I know I've ran into some real bad problems with Zoom before. I do know that it's just an adjournment, and I did speak with the city attorney about adjourning for progress on the license.
Okay, how
I
much
can.
time do you need?
I need him to speak with my licensing guy, so I don't really know where his license is at. I think 30 to 60 days will give us a clear picture and let me know what I need to do to get it back for him.
Okay. You can give me 60 days.
June 3rd at 8:30.
June 3rd at 8:30 work for you?
I believe it's going to have to. I can't imagine I have anything on my calendar that far out. Yes, it works. Thank you.
Okay, we'll do that. We're all set for today.
Thank you very much. I'll notify my client.
Thank you.
Bye now.
Let's say thank you.
Which one? Oh, yeah.
Why did she keep on muting?
Sorry.
I don't see a file in here for Matthews. Am I missing something? The physical file? That's probably why. On the record in the matter of Sparrow Hospital versus Janae Matthews, 2300393 GCE. Counsel, can I have your appearance, please?
Thank you, Your Honor. Michael Dean, P 81730 for the plaintiff.
Okay, and then Ms. Matthews is present via Zoom, virtually without counsel. This is a motion hearing, I believe. Ms. Matthews, you filed a motion for installment payment, and counsel, you have objected to that, is that correct?
That is correct, Your Honor.
Okay, and so Ms. Matthews is indicating that her average income every 2 weeks is about $900. And that she's requesting to make payments of $50 every 2 weeks, about $100 a month. Is that correct, ma'am?
Yes.
Okay, let's see. Okay, so counsel, it looks like the plaintiff is willing to accept the $50 monthly payments, but believes that the start date should be within 30 days. Is that the issue?
Yes, that was written in there. I believe they understood it to be $50 bi-weekly. They would accept it if it could start earlier. In the alternative that it be denied. This is the same payment plan that was entered in back in July of last year and subsequently set aside in October.
Okay, sounds good. Okay, and so I agree. Why would we wait until June to make a payment? Why can't you make a payment within 30 days?
I can make it within 30 days. It's just the last time when we did this, they took a long time to notify my employer. So on top of me paying them, I was still getting garnished, and it's already coming out more than half of my check.
Okay, that makes sense then. Okay. If you get an installment payment order, ma'am, and you don't comply and it has to be set aside, the law only allows you to get away with that once. The next time you can make a motion and it's going to be denied because you've already had one. And you've not complied. So you have to make sure you're compliant, or that you're in contact if there's a reason why you're not going to be able to move forward with your installment payment order. As it relates to your request, I'm going to grant the request for an installment payment order. You will make payments of $50 bi-weekly, which is your request. However, your start date will be 30 days from today's date. So it'll be no later than the 25th of April, okay?
Okay.
I'll sign and date the order for today. Any additional matters for the record, counsel?
No, Your Honor.
Okay, you're all set. Thank you.
Thank you.
Thank you.
Okay, that must be this file. Is Thomas Lippincott here? He's meeting with Jeremy Henley now. That's his physical file. I wonder what the method is as to which gets physical files and which doesn't, because I don't have a Lippincott file here. That's what I'm saying. It's an 08 file. So what's the method? Like, I'm trying to figure out which ones they decide get physical. I'm not following the method, but that's fine. Let's see. Mr. Smith is on that one.
Mr. Henley and I are back, Your Honor.
Okay, how are you proceeding on Henley?
We had a good conversation, Your Honor. There are some documents, though, that are responsive to the subpoena relating to employment and a banking relationship. I'm going to get in writing to him, reminding him where to send that stuff. 30 days should be enough time for him to do that. More importantly, we've agreed to a wage assignment at $25 per paycheck. He'd like to give me permission just to prepare that, sign his name to it, and submit it straight to the court.
$25, you said, a month?
Per
Or-
pay period,
Per pay
25
period,
per pay period, correct.
Okay, and that's correct, Mr. Henley, as to how you want to proceed?
Yes.
Okay, and you're giving Mr. Smith permission to sign your name to that document?
Yes.
Do you have any questions for the court?
No.
Hey, you're all set for today.
All right. Thank you.
Thanks, Jeremy.
Thank you.
Yeah.
Thank you. Mr. Smith, you also, was Mr. Lippincott removed, or he's not
No.
here at least?
Yeah,
Okay.
we had a creditor exam with Lippincott, show cause on Pierce, and a creditor exam on Legalo.
Lippincott failed to appear. How do you want to proceed?
We'd like to file a motion to show cause, Your Honor.
Okay, that'll be granted.
Thank you.
That takes care of Lippincott, and then our last one was the discovery. Well, what's a motion? Kaylee Pierce is present.
I know she's not. She's on a cruise ship in Mexico. And here's why I know that. She called me after she got the order to show cause. I had told her on the 18th of March, I said, look, get me these documents that are responsive. And then if the ship's got Wi-Fi, just appear, because I'm going to have questions regarding these documents. She hasn't appeared, so maybe they don't have Wi-Fi. Here's what I'd like to do. I did get the documents, but I can, pardon?
Someone was raising their hand when I asked about Kaylee Smith.
I'm Legalo. If he's looking for Legalo, Lagalo, Ralph, that's me.
I am also here on Ralph Legalo.
Yep, that's another file. That's a separate
Yep.
file. Okay, thank you. Okay. He was just raising his hand when I asked about Kaylee Smith. Okay, so what do you want to do with Miss Smith?
So,
I'm sorry, Miss Pierce. You
Ms.
want a bench
Pierce.
warrant?
Well, here's what I'd like to do. I think she's back next week from Mexico, the cruise ship. I'm going to shoot her an email right now, reminding her she was supposed to appear today and to call me when she returns. If I don't hear from her by the end of next week, I'm going to submit a bench warrant for failing to appear today. Would that be appropriate, Your Honor, rather than just
Okay,
issue?
but if you do hear from her, then what?
If I do hear from her, I'm going to complete the creditor exam over the phone. If I'm satisfied with the answer she gives, I'll advise your clerk that we can consider the original examination complete. If not, I'll have to ask for another, like a control date, if you will.
Okay, so no bench warrant will issue if you don't hear from her.
Correct. Correct.
Okay. All right, so we're all set on that one.
Thank you, Judge.
Okay, and then Mr. Lagola is here. And do you have a device that you can get on Zoom with?
So,
Do you have a device with you that you can log into Zoom with? If not, we can get you on our
I
iPad.
don't have internet or anything.
That's fine. We'll get you on Zoom so you can meet with Mr. Smith. On the record in the matter of Ventnor Flats versus Michaela Williams, 24-08816.
Good afternoon, Judge.
Good afternoon.
Counsel, have your appearance.
Absolutely, Judge. Good afternoon, Jen Wilburn, P83143 for the plaintiff.
Okay, and ma'am are Michaela Williams?
Yes.
Okay, today was the date that was set for a hearing. This is for a motion to set aside a default judgment. Ma'am, Ms. Williams, you defaulted by failing to appear for your hearing for an eviction proceeding. And you've now filed a motion to set aside that default judgment. In your motion, you indicate that you have different agencies seeking to help you, but that you also, you said the court, your previous court date was under your acknowledged because you was told a different date for March 8th. Who told you March 8th was your court date?
Yes, in my meeting from the last court, whoever I
told you
met
that?
with, I don't remember his name, but he said March 8th. That's the date I had down. When we had our
Okay, so
breakout or whatever. I don't remember who I spoke with though.
what date did I tell you?
I believe March 8th as well.
I did not.
Okay, well, that's what I heard. Excuse me.
What date did
Out
we
there.
send a letter in the mail? With that same date, we mailed you a notice in the mail. It did
Yes,
not
ma'am, and
come
I did
back.
not get that. No, ma'am.
It did not come back to the court undeliverable.
Mm-hmm. Yeah, I didn't get it
And so,
though. That's why I didn't
oh,
appear, because I didn't know it was under my acknowledgement. I didn't know anything about it.
counsel, did you want to respond?
Briefly, Judge, it's plaintiff's position that there is no good cause or meritorious defense. Even if the court does find good cause based on the mix-up, there's not a meritorious defense outlined, which is required to set aside the default. So I would ask that the motion be denied.
I'm struggling with even with the good cause, because I do landlord tenant hearings the same all the time. When I do pre-trials, I verbally tell you what your next court date is. So if you later go into a breakout room with someone and they say something different than what the judge told you, I would go back to the main courtroom and ask the judge, well, what, you told me it was this date. What date is my court date? So that I make sure I have it accurately. That never happened, ma'am. In addition to that, I know that I have a document here that tells me that you were mailed a note. And see, right now, even as I'm talking to you now, you're preoccupied with putting food in your mouth or whatever you're doing in the background. And that's probably why you can't pay attention. I'm telling you,
Excuse me, I'm at work.
I
I'm
don't
at work,
care.
but yes, can we continue?
I don't care where you are.
Ma'am,
You are in court.
continue, because I need to
No,
get
you
back to
are in
work. I
court.
need to get back to work,
You are,
so continue. I
well,
need to
get back to work
so
then.
continue.
Your motion is denied. Your motion is denied.
Okay,
Bye.
y'all have a good day. The fuck? Fuck y'all, bitch.
She's gonna pay her rent. You're all set, Ms. Cox.
Thanks, Judge. I have one more.
Is Michaela Williams still here? Jolly Flats versus Destiny Kaiser, 25-00521.
Afternoon again, Judge. Jen Wilburn, P83143 for the plaintiff.
State your name, please, ma'am.
Destiny Kaiser.
Okay, let's see. This is a motion to set aside a default judgment. Okay, and Ms. Kaiser, you filed this motion after failing to appear for your hearing. You said your phone was cut off and my phone was cut off and no serve for the Zoom video, and I just started working again. You were supposed to appear in person for a hearing, so Zoom wasn't an option.
I have the paper still. It said Zoom or in person.
For a hearing? Did she appear?
Yes, the very first time I had the very first.
Oh, so you failed to appear for the pre-trial?
Yes, the very first one I had. It was my fault. I had read it wrong. I thought it was only for Zoom, but it apparently was for in person and Zoom. But I didn't know that it was in person. But the Zoom was my fault because I didn't have Wi-Fi at the time, and I don't know anyone here, so I didn't know how to even get on the Wi-Fi. So it was my fault.
You failed to appear for pre-trial? Okay, did you have a defense as to the evictions? This is an eviction for, is it for non-payment rent?
It is for
Do you have
non-payment.
do you have a lawful reason why you have not paid your rent?
Yes, I was keeping in contact with the landlord. My father had passed away. I'm the oldest and only child, so I wasn't responsible for a lot of things. So I had to put some things off, and by requiring me doing that, I lost my job. So that's what happened. But I do have my job back, and I am working again, so yeah, I can pay the.
I'm sorry to hear that you lost your father and that you had a lot on your plate. And those are difficult things to navigate, but those are not actually lawful reasons to withhold your rent. So when I asked for lawful reason, I'm asking, was there a condition with the property, or did you have some agreement that's from the landlord that said you could pay your rent late? Or was the property uninhabitable? That's what I mean.
No, it was just
Okay.
due for me not paying rent.
And so, well, without having a lawful reason or meritorious defense, the best you can do is meet with Ms. Wilburn to see if they will give you an extension to pay the past due rent, or come into some kind of resolution. I'll put you in a private meeting room to discuss it.
Yes, ma'am.
And see if you can come to a resolution. If not, I'll make a ruling on the motion.
Okay, thank you.
Thank you, Judge. And could I also have the property manager, Ms. Williams, placed in that breakout room as well?
Okay.
Thank
Room
you.
1. Okay, Mr. Smith, did he meet with the person that was? Mr. Smith, are you all set with the last person, Mr. Legalo?
We are, Your Honor. I'm gonna get in writing to him on a payment plan arrangement we reached and some documents that need to be produced. He seems like a great guy. And so I think we are good. If I don't see the documents within 30 days, though, we'll file a motion to show cause on the production. Other than that, I think we've completed the Q&A part of the exam.
Okay, let me go here and note here that the discovery matter has been resolved, or the examination took place. If we don't get the documents, or if you don't get the documents, you'll file a motion to show cause.
Yes, Your Honor, exactly.
You have any questions for the court today?
No, ma'am.
Any additional matters for the record, counsel?
None, Your Honor. Thank you.
Thank you. You're all set. Thank you.
Thank you, Ralph.
Thank you.
You bet.
Thank you.
That was done. Eyes are done. Mangallo was just done. What's your name, ma'am? Dorothy Washington. Your name? Let's see, on the record in the matter of Diamond Sanders versus Dorothy Washington, 25-00034. State your name for the record. Diamond Sanders. And state your name for the record. Dorothy Washington. Today was the date scheduled for a pre-trial. And you all are both without an attorney, correct? Both, correct. And this is, I have just reviewing the claim here. The complaint that I have says you're suing for $21,000, $21,500 for 2020 Chevrolet Equinox. Is that accurate?
The property, just the property, not
It says plaintiff is lawfully entitled to possession of the following property with an estimated value of $21,500. Property described 2020 Chevrolet Equinox. You put that on there?
it might be title. I'm not sure.
Personal property in the home of 206 South Butler Boulevard, Lansing, including clothing, footwear, electronics, and hygiene products?
That's correct.
Okay. You do know that there is okay, so let's see here. Did you used to live there?
I did.
Okay. Is Washington? Okay, and then you moved out?
No, I didn't move out.
Okay, you still live there?
I was illegally evicted.
What do you mean illegally evicted?
Just a wax change on me.
How long have you been, you were paying rent? You had a lease?
Nope, just living with my mom.
Oh, this is your mother? Oh, okay. You living with your mom and then it went south and you got unhoused with your mom.
That's correct.
Okay. And when you got unhoused, you had clothing there and electronics?
Yeah.
That you believe amounted to 21,000? I'm sorry?
A vehicle that she took out of my sister's driveway because she's a co-signer and just hid it from me, so I have no clue where my car is.
Oh, okay, so so you did put the 2020 Chevrolet Equinox on there. Okay, so you are suing for Chevrolet Equinox and other things. That's why I asked, okay, how did we get to $21,000? Because I was gonna say that's a lot of clothes.
Oh, gotcha.
Okay, all right, so typically if you were represented by an attorney, you would be doing a joint pretrial statement today. But you're not represented by an attorney, and so typically my court officer would assist you with that. However, I am going to have her give me a joint pretrial statement, and you can have a seat. I'm going to do this one with you in her presence because this seems like it could be a little bit more complex. I don't have a lot in the summons and complaint. You can have a seat. And then I'm going to review your answer. But let me see if they're ready in the other matter really quickly. Off the record on that. Let's see, Ms. Wilburn, did you all come to a resolution at all?
At this time, Your Honor, my client is not agreeable to setting the judgment aside. We would ask that the motion be denied based on there being no good cause or meritorious defense. I did advise Ms. Kaiser. She said she has not applied for any rental assistance. I did advise her to call the court and speak to, try and get a hold of Ulysses to see if there's any resources he may be able to provide to her.
Wrong file. Let me go back into this file. I think I accidentally closed the cards file. Let me see. Where I go? File cabinet added. I accidentally closed that file, I think.
Oh, to go. You completed it?
I must have, because I don't see it in here. Okay, let me go on the file cabinet. That was the right. Let's see here. Okay. Okay, Ms. Kaiser, you can unmute. I've just, again, you did not exactly provide the court with good cause. The court rules are very clear as to when we can set a default aside. And the court rule says that in order for you to get a default set aside after you have missed your court date, you first have to provide the court with good cause as to why you missed your court date. I think you did have some good cause. I think that you mixing up your phone, your records as it relates to whether or not you can appear, and you didn't have a working phone, probably because you were unemployed due to the loss of your father, could cause you to have good cause to miss your pretrial date. And I just look, you did miss a pretrial date as opposed to a hearing. Pretrials, you can appear via Zoom or in person. It's the hearing that you must appear in person. But it was your pretrial, and if you had appeared during the pretrial, you would have been notified then that you could meet with Mr. Rosa, or that if you got assistance from any of the agencies, that the matter could be stalled or postponed while you work through getting a promise to pay or assistance with them. However, where the court doesn't have sufficiency is good cause. And so I can't say that because you lost your job that that's good cause to miss your court date. I'm sorry, a meritorious offense is where you don't have. I can't say that's a meritorious offense to why you missed you didn't pay your rent. You have to give me a defense under the law as to why you failed to pay your rent timely, and I don't have that. So because of that, I'm going to have to deny your motion, okay? However, they have already indicated to you that you still have some recourse, which is to get in contact with some of the agencies. You should contact Mr. Rosa. If you have a pen, I'm gonna give you his number now.
Yes, I'm ready.
Yep, his number is 517-483-7608.
517-483-7608.
Yeah, 7608. Contact Mr. Rosa immediately and let him know your situation and that you need to get some assistance or some promises to pay immediately. You should also contact, his name is Joseph McDonald. He's the city housing ombudsman, okay? He's here on the 4th floor of City Hall. And you can Google his number because I don't have it off the bat, but Joseph McDonald is also someone who can assist you with trying to locate some resources. It sounds like if you could get some assistance, that the landlord would be willing to work with you then.
Yes, ma'am.
Okay?
Yes, ma'am.
Okay. Okay, so do
I
you have
have a
any questions?
question. I'm sorry. Yes, ma'am.
That was what I was asking you, if you had any questions.
Yes, I'm going to take care of this right now. So when I do it, do I just let the landlord know? How long do I have? I mean, I've never went through this, so I don't know exactly what I'm supposed to do.
You would make contact, and then you should get in contact with your landlord or your property manager immediately to see if they will enter into some type of payment arrangement in lieu of executing the judgment against you, okay?
Yes, ma'am.
Okay. Do you have any other
Thank you.
questions?
No, ma'am. Thank you.
Any additional matters for the record, counsel?
Nothing from the judge. Thank you.
Thank you. I don't know if I have an order, but let me double check. Can you produce an order, Ms. Wilburn?
Sure, Judge. I'll submit orders for both of the cases.
Thank you.
Thanks. Have a good afternoon.
Same to you.
Thank you.
What did you do with the Everybody's been responsible.
I was wondering if the court would consider caution more than just
Okay.
yes, I usually one early 1:30.
Oh, okay.
Top of 1:30. I did talk to
Miss Day, I'm glad you came because I had a hold for 14 days on you. Why were you not here on time?
I had pretty much got off of work this morning and I had came this morning, so I thought it was at 9. And then she ended up telling me to come back at 1 and out.
Well, that's not good. You could have took care of it at 9.
I didn't know she was here. I think she.
Yeah, I know.
She didn't tell me. She just
Yeah.
told me to come back.
Your attorney was here and so was the city attorney. We could have taken care of it early. Do you know what? I know that this was adjourned for her to, I guess, work on some compliance.
Yeah, I talked to Mr. Waddell about her, just 'cause I kind of thought I knew what was gonna happen today. She's paid off the bulk of the fines, and there's just a couple left here in 54A, so we were gonna see the 30-day adjournment of the child fines, because I think that's the only hold left on our license.
Yes, I'm here.
She believes so. She touched base with the window earlier today, and there was some discrepancy with what she was told last time in court and what they told her at the window, so I was gonna be looking into that for our next hearing. She thinks there's a couple of, at least a couple of additional fines to finish paying here.
Okay, sounds good. What is she supposed to be paying off?
She thought there was a no insurance. She did have some confusion for me today that I was gonna be looking into because she was told that there was, and was the court who told you that last time, not me. She remembered in court last time, I think you advising her of some of the fines that would have to get paid, and then some of them she didn't have to pay to get the hold lifted, and then the window towards them. She thought it was 300 she was gonna have to pay here.
And when I talked to her earlier, she said it was over 1,600.
Yeah, she's on a payment for that. It looks like that's what she. Okay, it says payment. Okay, first payment's due on the 25th of next month. Huh? Yeah, $50. For $50. Beginning in April. Our last payment of $16 will be due in 2027. So how much time do you need?
We'd be asking for at least 30 days. I don't know that she's paid all of it to get the hold lifted, but I wanted to touch base with Ms. Taylor about that later in the week.
So she has multiple files, and so which one is actually giving her a hold? Because none of them here.
I'm not sure at this time. Sometimes Ms. Taylor is able to tell me what Secretary of State constitutes a hold. I don't know for sure because I'm not permitted access to writing records.
Yeah, and then the lady said that it was a foul on there that she couldn't find. What really needs to be taken on too.
That one is pending though. It can't be the pending one, I don't think, but I don't know.
Yeah, there are a couple of cases that she was here.
She has 2 disposition tissue 200 on. Click on that, see if she has a whole Secretary of State suspension in there. She does. Okay, she does have some suspensions on some of these. They have it all in. She owes a total of $1,200. She's paying $50 a month. They have her on a payment plan since 2027. I don't know how they're expecting her to get the suspension. I'm going to reset it. I just need her to get her when she gets here. If they tell you at the front desk that you're too early, come to the court and ask, come to the actual courtroom, because your attorney was here and the city attorney. I need to pull the files. If there is a case that she can pay that's holding that particular case, I have to go in there and make them apply her money to that one. Otherwise, they won't do that. They go in a chronological order, is my understanding. But I can't do that today because it's kind of late here and I have to do
Understood.
It's 2 of them. It's 2 of them. So it looks like she has 2 that's holding her 200. Her license that she owes 200 a piece. So it'll probably take her a couple of months to pay that. And I could potentially look in there and see if I can waive what I typically waive. But
So if I emailed you maybe in a couple of days.
I can pull all of her files and look and see what's going on in there. So I'm gonna reset it so that we can have time to do that.
Thank you very much.
Do I do a warrant on this? Not yet.
No, not yet.
Okay.
So April 15th at 10:30.
April 15th at 10:30. We'll get you a notice to appear.
Thank you so much, Your Honor.
You're welcome. Okay, thank you. I don't need two of these. Let's see.
She printed one out for me and I had found.
Yes, it's just a triplicate, but we'll hold that for next time.
Okay.
Let's see. Get back with these parties. You filed an answer, correct, ma'am?
Yes, I did.
I didn't know how to get out. Oh, there it goes. Okay. Your answers state. Someone assist you in filing this answer?
I have a couple of friends that are in the legal field.
It looks like it.
Yeah.
Okay, the defendant denies the plaintiff is entitled to lawful possession of the described property, although plaintiff and defendant are co-holders on the title. Plaintiff has failed to pay the underlying, okay, so.
I can put it in the gist if you like.
No, it's,
Is it well like it is?
you can put it in what?
I mean, I could sum it up if you want.
No, this was excellently written. That's why I asked if you had assistance. It looked like an attorney drafted it. Okay, I'm going to put the pleadings are in order. The issues is over property, a property dispute. I'm going to skip motions. I'm going to have it set for trial. I don't see that there was a jury demand. I think it'll take you about a couple hours to present your case.
Yeah.
Okay, you have any exhibits?
I do. I have them on my phone.
Yeah, you need to get them off your phone and in paper form for trial, okay? You need to bring a copy for yourself, a copy for the court, and a copy for the defendant as well. That goes for you as well. If you have exhibits, I need them in paper form. I don't like going through people's phones. That's how you see things that you don't want to see. And then any witnesses that you need assistance subpoenaing, you would need to report to the court to get that done, okay? You need to do it 30 days prior to. I'm gonna have it set for trial as soon as possible. Do you anticipate calling witnesses?
Yes, sir. I can call.
Who do you anticipate calling as a witness?
One of my sisters.
Your sister is a witness, so you don't necessarily need a subpoena for that, okay? Do you anticipate calling witnesses?
Yes, I may have to call 3 coworkers.
Co-workers?
Yeah.
And what value do they add to the case?
My daughter came to my job threatening to make me lose my job. The same day I had to put the car up, and so she was looking for me at work, pretty much stalking my work locations.
I don't know that their testimony is actually relevant to the issue of whether or not she has a lawful right to the property, though.
Okay.
So your witnesses would be able to testify as to whether or not you have a lawful right to withhold this property if there's actual property that's missing. So that's all the evidence you would need to present, is why you would not have any property that you need to turn over to her. I don't need to get into, I don't even care why you had to kick her out. That's not why I'm only here about the property.
So when we meet again, we won't be dealing with any sort of what was stated as an unlawful eviction at all.
She's not suing for unlawful eviction. She's suing for return of her property.
Oh, because it was put on the paperwork, so I just.
That's not in the paperwork that I have, though. She said that she she's suing for $21,500 for a vehicle and some clothes.
Okay. Let's see what, I'm trying to think of what witnesses I would have for that. And I may not need to call in any witnesses. I may not need to. Because right now, because I didn't know you were gonna ask me that question, I can't think of anything, but if I do, can I reach out to the court?
Absolutely. If
Okay.
you need help with subpoena, you would just go to the clerk's office on the 5th floor. And I'm only asking you that because I'm telling them to set this for a trial as soon as possible. Because I don't believe that you need a discovery period, nor do I think that you all will be filing any motions. Do you have any questions at this time?
No, Your Honor.
You're all set for today. You'll get your next notice in the mail. Did you provide an address?
Yeah,
that
I have
you
to
mail?
update my address, actually. Should I do that here?
Yes, what's your address?
It's 12101. It's Canandaigua. Can I spell that for you?
Yes, please.
CANADAUA.
CANANDAIGUA.
Thank you. Unless you have any questions for me, you're all set. Did you get it? Respell that for us, please.
CANANDAIGUA. Road, next month. 9256.
Did you say this was gonna be a jury or?
Non-jury. That'll be before me.